All rise. Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable Rand Wallace, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session at the 5th District Court of Appeal. I've been previously introduced. I would like to introduce the other members of the panel. To my right and your left is Judge Wendy Berger, and to my left and your right is Judge Brian Lambert. We have 3 civil cases that are on the docket today. Prior to beginning oral argument, I would ask that everyone please silence any noise-making devices, cell phones, so we don't distract the lawyers that are giving their arguments. And the civil cases, all 3 civil cases, have 20 minutes per side. And as the appellant, please let me know how much time you would like to reserve for rebuttal. And with that, the first case that we have on the docket is MOOTRY versus BETHUNE-COOKMAN et al. And when the lawyers are ready to proceed, you may.
Ready, Your Honor.
Okay, how much time would you like to reserve for rebuttal?
5 minutes, please.
Okay.
May it please the Court. My name is Jerry DePaul, and I represent the appellant, Dr. Russell MOOTRY. The trial court erred by denying Russell MOOTRY's motion for partial summary judgment as to liability on count 1 for breach of contract. The breach of contract claim is two-pronged, 2 breaches alleged. One, Dr. MOOTRY's was employed by BCU, and he was tenured. He was employed under a faculty contract that could only be terminated for cause and only in compliance with the disciplinary proceedings set forth in his faculty contract and faculty handbook.
Let me ask you about the contract itself. I understand he's a tenured professor. The first paragraph of the faculty contract offer indicates the contracts are issued on an annual basis regardless of tenure status. And so this contract at issue in our case is from July 1, 2008 through June 30, 2009, and he was terminated in the end of May, I guess, of 2009.
Yes, sir.
Regardless of all these events, whether they did or didn't happen, and et cetera, at the end of 2000, couldn't they just have not renewed his contract? So we're talking about a few months of damages?
No, Your Honor. While the contracts are issued on an annual basis, tenure is defined in the handbook as the right to continuous appointment absent cause. So he has the right to receive those annual appointments on every year. So, I mean, the annual contracts define, you know, his salary, his position, and things of that nature, but his tenure grants him the right to continuous appointment. That can only be terminated.
So he unless he has committed some act that justifies his termination for cause, even though the contract language itself says it's issued on an annual basis regardless of tenure status, he has a right,
Right.
assuming he behaves himself, for lack of a better term, to have a continual annual contract?
Absolutely. I mean, you know, because the contracts are issued on an annual basis. Tenure means he has the right to a continuous appointment. So,
The second paragraph says that the university is obligated to notify other faculty members in writing not later than January 15 if the contract will not be renewed. So you're saying that, let's assume this happened in December of 2008. The university couldn't just say, you know what, before we get through all this stuff here, let's just suspend this guy for 6 months, send him a letter prior to January 15 saying, oh, by the way, we're not renewing your contract for July 2009 through June of 2010, and let's just be done with this guy. They couldn't do that under your interpretation of his scenario?
that's correct, Your Honor. Under my interpretation, he's entitled to continuous appointment, and, you know, the notice would apply presumably to somebody who is either not tenured or, you know, he has a right to continuous appointment.
Language, regardless of tenure status, to you, your interpretation, that's really just superfluous language in the context of a tenured professor at Bethune-Cookman.
Well, I mean, I say at worst, it's maybe, I mean, the tenure is defined in the handbook as continuous appointment, so.
What would be the purpose at all if you can never cancel the contract?
Well, they can terminate the contract for cause.
If there's basically no end to a contract for employment, if there's basically no end because as a tenured employee, you're entitled to continue your work
Right.
unless some event happens for cause,
Right.
then what would be the point of an employment contract and a term of an employment contract?
Well, the faculty contracts define his salary, his benefits, the term, his position. He was, full professor of sociology in the School of Social Sciences, as well as the dean of the School of Social Sciences, and all that's set forth in the annual appointment contracts. So it sort of specifies some of the terms that would apply for that academic year. But he's entitled as a tenured professor to continuous appointments and to receive those faculty contracts on an annual basis unless he's terminated for cause.
In terms of your motion for summary judgment on the breach of contract claim, and there are a lot of undisputed facts,
Right.
that being that there was a contract,
Right.
one, but one of the elements is that there has to be a material breach. And so why wouldn't the issue of materiality be one that is a factual issue for the jury to decide, which would preclude a summary judgment on that particular claim?
Well, in this case, there's two bases for the breach. One, that he was terminated without cause, that the school never proved cause, and two, that the Bethune-Cookman University didn't follow its disciplinary procedures. So, in either one of those would be a material breach. There's the faculty handbook that sets out a 3-page sexual.
Certainly, it would be a breach,
Right.
perhaps, but materiality, isn't materiality a question for the jury, a factual question?
Well, I'm at a loss to understand how it would be immaterial to terminate him without cause when he has a contract that protects him. The contract is for that specific purpose, so that he can't be terminated absent cause. And to terminate him absent cause just totally defeats the entire essence of the contract. And that's how it's material. That applies to the termination for cause as well as the violation of procedures. Because as a tenured professor, if he can't be terminated absent cause, they need to go through the process to substantiate that cause. And if they don't do that, he's basically an at-will employee. It defeats the whole essence of the contract. So it can't be immaterial to just convert him from a tenured professor who has the right to continuous employment to an at-will employee, essentially. That's what it would do. It just gut the entire contract. The summary judgment evidence, as you mentioned, is basically totally undisputed. And by that, or uncontroverted at least, it's undisputed that Bethune-Cookman didn't follow the process in the handbook under the sexual harassment policy or the general termination provisions.
But doesn't the summary judgment issue become moot, though, if you actually go to a trial and there is evidence, arguably some evidence that suggests sexual harassment, and therefore, in other words, the determination of the summary judgment by the trial court, if it's an issue of law, that's one thing, but if the judge determines there's a factual issue that needs to be addressed and then it's addressed at trial, doesn't that moot the issue of the summary judgment motion?
Generally, yes, but under the case of Ioannidis that we cited in both briefs, the exception to that is that if you go to trial and you don't get a fair trial, essentially, and there's errors at trial that deprive you of a fair trial, then that doesn't moot the denial of a summary judgment. The denial of a summary judgment motion that's gone through a full-blown trial can still be reversed on appeal if there's errors at trial that deprive you of a fair trial. And that's what happened in this case. And that's why we've not only appealed the denial of the summary judgment, but also there's numerous errors at trial with the admission of gross hearsay throughout the entire course of the trial.
Ask you about that report. Was any of that report redacted before it was admitted into evidence?
No, sir.
So Mr. Brewer's opinions about the conduct and what he thinks should be done, that was all given to the jury?
It was given to the jury in its entirety. And I would submit that the only relevant portion of that entire report would have been the conclusion. And the conclusion is that there was a perception of guilt There's a perception that Dr. Mootry engaged in these activities that he was accused of. There was never any finding that he actually did these things that he was charged with.
Did the report differentiate between the 3 or 4 individuals that were the subject of the report as far as their actions and what actions came before the jury?
Yes, it did. It opens with a little summation, and it lays out a little summary under each professor's name. And again, like I said, it's not findings of what they did. It says, Dr. Russell Mootry allegedly A, B, C, D. The next professor, allegedly A, B, C, D. It goes on. It gets into the meat of the investigation report. And there it says, I talked to professors and students who all want to remain anonymous. One professor who wants to remain anonymous says she believes they did these things, but has no personal knowledge of it. Another professor says she has no personal knowledge of these things, but believes these professors are engaging in inappropriate behavior. So the entire report itself does nothing in the way of establishing that there was cause to terminate Dr. Mootry.
So is Bethune-Cookman terminating these other professors who apparently were aware of sexual harassment, didn't report it?
I'm sorry, can you repeat the question?
It was somewhat tongue-in-cheek. I mean, apparently, if I read Brewer's report, there's lots of professors who have information on the Bethune-Cookman campus of sexual harassment regarding this social program or sociology department.
Right.
It's not like any of those people were being terminated for
Right.
reporting.
No.
Isn't that one of the 2 grounds that your fellow is being terminated upon, for the sexual harassment in and of itself, and then his awareness of sexual harassment by I guess it was referred to as the Nigerian mafia people here, and that he didn't report that to the higher-ups?
Actually, that is not a basis for the termination. There's no basis in fact for that assertion that they raised at trial, that he was terminated for that reason. The second reason being that he knew of but didn't act, knew of sexual harassment but didn't do anything to stop it. His termination letter is what establishes what he was terminated for. And all that says is he was terminated for sexual misconduct with female students at the university, period. Not for being the dean with knowledge of sexual harassment and not stopping it. No mention of that anywhere. He got the exact same termination letter as the other 3 professors who were not deans of any school. That theory was never raised until we set foot in trial. And then that opened the floodgates to another wave of hearsay for professors to get on the stand and talk about this culture of fear, this culture of inappropriate behavior, because he knew or should have known this was going on as the dean and didn't do anything. He wasn't terminated for that reason, so that shouldn't have been an issue at all. It's irrelevant, and there should have been no evidence introduced to support that theory. And we objected. We objected that it wasn't raised in the pleadings, and there's no basis in fact for it.
How do you respond to their argument regarding I guess their outside counsel turned into an expert witness and started opining that, paraphrasing, that she gave them guidance, or Bethune-Cookman guidance, and they didn't violate any provisions of the contract or the handbook, and in her opinion, due process was given?
I'm dumbfounded by that, to be honest. I'm still at a loss to understand how she was converted from a fact witness into...
Their argument on appeal seems to be, well, you opened the door
Right.
to, well, maybe not you, but your side in trial opened the door to it.
Right.
What's your analysis as to they opened the door?
Well, they conclude that, but they don't say how we opened the door, and they reference 3 pages of the record to say, he opened the door, see this page, that page, and that page. I went back and looked at it. There's no expert opinion questions asked anywhere there. And I'm still lost for how we opened the door. At trial, there was no discussion about how the door was open. It was just, they asked the question, we objected, they said the door was open, and the trial court agreed. There wasn't any, this was the question that was asked, and to this day, I still haven't heard what the questions were asked to open the door. But I reviewed the record, and I don't see a question in there that's going to open the door to any expert opinions about whether or not Dr. Mootry was prior to due process. And even if any such opinions could come in, even if, they're totally contrary to the actual facts in the case. Ms. Parsons testified, she testified to the facts as well as her opinions, and before she gave her opinions on redirect, she admitted that Dr. Mootry was never given a pre-termination hearing that he was entitled to. She admitted, or she acknowledged, she had no idea if he was ever given a list of the charges with specificity. So, and she said she wasn't involved in the process. So with that, how can she go from saying, yeah, they didn't do A, B, and C, to, but in my opinion, they did it? It doesn't make sense. You can't give an opinion that they did things that factually they didn't do. Her opinion, they complied with all of his due process rights, yet didn't give him a hearing. It's just nonsensical, and it should have never come in for that reason alone, regardless of whether the door was open. It just had no basis in fact. So between the Brewer report, which is an adulterated compilation of, anonymous, unsubstantiated rumors, but we don't even know, how do we know they're students that talk to Mr. Brewer? The only reason that we're calling them students is because Brewer said that they told him they're students. That's hearsay too. Bethune-Cookman doesn't know of a single student that complained against Dr. Mootry to this day. Well, sorry, they put Raquel Tapia on the stand at trial, who testified that Dr. Mootry made comments in his social stratification class, which has to do with where people lie on the social spectrum in society, and she said that he made comments to the effect that all women are good for is laying on their backs. She admitted, though, that that was an appropriate topic for the class, and it sparked a classroom debate, and her only problem with it is that she didn't have a problem with him raising the issue. It was just, she would have preferred he would have said it in a little less provocative way.
You're in your rebuttal time, counsel. Just wanted
Thank
to
you.
let know.
The summary judgment, we were denied. There's absolutely no evidence that they complied with the contract. There was no evidence of cause. There wasn't a single scrap of evidence in the summary judgment record of a student complaining, hey, I was sexually harassed. All the evidence in the summary judgment record was faculty members who had no personal knowledge of anything, pouring hearsay into the record. Someone told me this, I don't know who it was, someone said this. That was the summary judgment record as to cause. And as to whether they complied with the procedures, they admitted they didn't. They didn't do really any of it. They sent him a termination letter, and then they followed it with an appeal where, they added documents that didn't exist when he was terminated. They denied him his right to counsel. It was all a sham. So I'd respectfully submit the denial of the summary judgment motion was error based on a record that was, Mootry proved that he didn't do anything, and they didn't put any evidence up to controvert that. And then when we got to trial, and this is important too for purposes of the summary judgment motion, the trial was not fair. The rules of evidence were thrown out the window. All the hearsay that they wanted to get in came in, and there was a curative instruction after the Brewer report came in. The first thing that happened when Mr. Brewer was done testifying, the eventual jury foreman asked, Mr. Brewer, how many students accused Dr. Mootry of sexual harassment? So, we got this curative instruction, and all they want to know is, give me some more dirt on this, on these anonymous students accusing him of sexual harassment. And the curative instruction on top of that compounded the prejudice because it interjected a legal standard that doesn't exist in contract law, which is good faith. The curative instruction informed the jury that this evidence is used to prove the university's knowledge and good faith in the actions they took. With that, I would respectfully submit that, the trial court erred by denying summary judgment, by allowing all the evidence in, totally deprived Mootry of a fair trial, and the verdict is totally unsupported by the evidence. And I ask that this court reverse, remand with instructions to enter summary judgment in Dr. Mootry's favor, or in the alternative, to grant a new trial. Thank you.
Good morning.
May it please the court, good morning, counsel. My name is Scott Cole, and along with Brian Rubenstein, we're here on behalf of Bethune-Cookman University. Judge Lambert, you and Judge Berger asked a couple questions which demonstrate why summary judgment was appropriately denied in this case. First and foremost, you pointed out point 1 of the contract that said contracts are only given on an annual basis. Now, counsel pointed out that there is a discrepancy between the contract and the faculty handbook, which is why Judge Perkins felt that summary judgment should be denied. First and foremost, he said, because of those ambiguities and because there's reasonable interpretations between the documents, it's a jury question as to determine what is the contract and what is the handbook and what language is appropriate. The jury is up to the jury to determine those ambiguities and find out if a contract or the handbook applied, and the jury did so. And Judge Berger, when you asked counsel about the material violations allegedly of the due process that was given to Dr. Mootry, that's exactly what Judge Perkins said. He said, it is true that Bethune-Cookman did not follow to a letter each and every one of the due process statements in the faculty handbook.
However, they came very close to following it, quite frankly.
Judge Lambert, I would disagree with that for several reasons. First and foremost, really the only thing they didn't follow was the appointment of an investigatory committee at once the allegations of sexual harassment came forward. But what they did do is they had an independent investigator follow up on those allegations, which is what the committee is entitled to do. They sent him a suspension letter on May 15th. They allowed him, with legal counsel, to go and meet with the investigator to determine, and he was told what allegations were made against him.
But he's given no information as to who, when, where these things are occurring. He's just saying, we believe we have grounds to terminate you because you are sexually harassing students. And he, it would seem to me, understandably inquires, well, who's saying that about me? Who are the people accusing me? I've been here for 30 years, I guess, or almost, and apparently Brewer's response is, that's all confidential, I'm not going to tell you.
Judge Lambert,
How is that not fairly violative of his right to do, if he's a tenured professor entitled to certain rights as compared to an at-will employee, why is, that seems extremely problematic to me.
Well, Judge Lambert, first of all, that's a jury question, and that's the issue that they raised on appeal, and the jury made their decision. But second, I would disagree with you in part. First, you are correct that he was not told at that May 18th meeting the who, but he was told what. For example, what he was told that Professor Paul McComb said that they being Dr. Mootry and the other 3 professors who were terminated, were passing around nude pictures of students. Professor McComb said it happened right in front of him. He was told that at that meeting. He was also told about issues about him allegedly sexual harassing students. In fact, he admitted that he hugged a student, which was inappropriate, although he claimed the student hugged him. He was also told at that meeting, and there's a difference of opinion what occurred at that meeting. Dr. Mootry testified to one thing, Mr. Brewer testified to another. That's a jury question. But during that
How does that make it any better that you have these unidentified accusatorial witnesses that are allowed to basically testify through the report at trial? He doesn't have any discovery that he can pursue and go into the underlying basis for the statements made in the report by these unidentified witnesses. How's that fair?
Well, it was fair, Judge Wallace, for a couple reasons. Number one, he was allowed to have legal counsel at that May 18th meeting. He was told of the allegations against him. He was also told that part of the reason he was terminated was because he knew sexual harassment was ongoing at the university and he did nothing about it. So it was 2 parts, not just what he did, but what he as the Dean of the School of Social Services did not do.
But he denied, at that meeting with the attorney, on the May 18 meeting, so he denies knowing any of that, and it seemed to be a fair question, certainly something I would ask, saying, well, who are you saying that I know is doing all these things? You're basically saying that person A, B, C in my department are doing these things, and I know about it. When are they doing it? What are they doing? How are they doing it? How do I know about this? I mean, and it seems like Brewer's response is, we're not going to give you any specifics about that, but we are doing our own investigation, and lots of people are telling us about it, but we're not going to tell you who's telling us about it, or even if those people know about it. You know, some of this report is double hearsay. Somebody told me that this happened, and now I'm telling you, Brewer, that this is what's going on. How is that not almost an egregious violation of due process rights?
Well, it was not an egregious violation because this is not a
You
criminal.
got to convince me it's not.
Well, I'm explaining to you
Running out of time.
It was not for several reasons. First of all, this isn't a criminal proceeding. The university is bound by the handbook. And one of the reasons why this was a jury question was because there was an ambiguity in the handbook as to which portion of the handbook they should follow. We argued pages 28 through 29, termination of a tenured professor was at issue.
It's clearly sexual, I mean, this is a sexual harassment claim. I mean, I understand the handbook says you can terminate somebody for moral turpitude and, you know, inefficiency, et cetera. But I mean, at the end of the day, this is, you're sexually harassing students and you will have a specific procedure for sexual harassment claims that clearly wasn't followed here.
Well, sexual harassment is also mentioned on pages 28 through 29. That's another reason why
I
you
know
can...
that, I understand, but I mean, it seems like, and correct me if I'm wrong, the argument is, well, I know we have a sexual harassment policy and procedure, and that's a grounds for us to terminate somebody, but there's also other grounds that allow us to terminate people under the handbook or the moral turpitude, conduct in violation of commonly accepted standards of morality. It seems like you're taking cover under those. It's a sexual harassment claim. There's a sexual harassment policy. You're saying, but we don't have to follow that because we're actually terminating him for moral turpitude and failure to cooperate within the bounds of accepted standards. And that seems kind of a quasi-shell game here.
No, Judge Lambert, I would disagree with you respectfully because, number one, first of all, at that May 18th meeting, he was told of his suspension on May 15th. He was already on suspension for not running a very good department. He let professors take vacations without having somebody teach their courses, for example. He was told on May 15th that he was being suspended, and he was told the reasons why. He then went with legal counsel to meet with Mr. Brewer on May 18th. He was told...
I apologize for cutting you off. It seems like your president says, well, look, we did what we had to do because we had exigent circumstances and we needed to basically stop this, and we had to do what we had to do, and it is what it is. And nobody's condoning sexual harassment. If he did what he is accused of doing, then he rightfully should have been terminated. But this theory of the exigent circumstances, so we got to leapfrog some of the due process, seems somewhat inconsistent with the next page of the handbook that you know, if I look at the bottom of the one page of the handbook where it says you can terminate for cause for moral turpitude, inefficiency, incompetence, et cetera, et cetera, et cetera. If I look at the start of the next page, it says, the president may suspend any faculty member pending investigation, hearing, determination of charges against such member not to exceed 6 months or until a final decision is made by the administrative board, whichever shall occur sooner. Such suspension may include a suspension of salary. As I read that, and correct me if I'm wrong, if your president says we have an exigent circumstance, we have this report that says this is rampant in this department, we need to make sure our students are safe. Here's what we're doing. We have a sexual harassment policy. We're going to follow that to the letter because we want to make sure we get rid of this guy the right way. MOOTRY, you are suspended. You're going to be suspended without pay for 6 months. At that point, you guys can give all the due process you want. You can tell him what's being accused, he's accused against, and if he has a chance to confront those witnesses or address it, etc., he's on notice. And then if you believe that there's good cause, then you say, you know what, you're now fired here. We've gone through the appeal process, etc. That strikes me as addressing this exigent circumstance umbrella position that's being taken here as the methodology that's envisioned under the handbook of Bethune-Cookman to get rid of this guy. Why wasn't that done?
Well, it wasn't done for several reasons. Number one, as you said, Judge Lambert, it was exigent circumstances, but that provision doesn't say 6 months. It says not to exceed 6 months.
I know, but you can, obviously, if you give him the due process and the administrative, I'm sure he would like to be concluded in 3 months if he could say, look, tell me who all it is, I'll go to your hearings, I'll have my chance to have my lawyer cross-examine or make my argument, have my appeal, and if it's done in 4 months as opposed to 6 months, and if I win, then I won't be out of pay for 6 months, only 4 months. So, but it does give the outset of 6 months that you could have ended the exigent circumstances by, I guess, doing it to all 4 of them, if that's the concern, gone through the due process procedure as outlined in your manual, and then however it turned out, it turned out. If it was just cause, then good riddance. But that was chosen not to be done, and it's compounded by the admissibility of rank hearsay in that report.
Well, let me address the first part first. And as I was saying, that on May 18th, he was given these accusations and told specifically the accusations against him, and not only what was against him, but what he failed to stop. He failed to stop sexual harassment, for example, passing around nude photos of students. Moreover, he had an attorney there. The other 3 individuals who were terminated were interviewed that same day, represented by the same counsel. That attorney had every right to conduct whatever investigation that attorney chose fit. The attorney did what the attorney did. He was then terminated several weeks later. He then had an opportunity to be heard again at an appeal committee, which he was. He had an opportunity to appoint 2 faculty members, which he failed to do, and the termination was upheld. So I would state that there is evidence of due process in the record.
Well, that's like
And-
saying to me that if the JQC sends me a letter that says, guess what, we're investigating you because we have information that you sexually harass people when you're on the court. And I don't at all. And I say, what the heck is this about? Who is saying this about me, JQC people? And they say, we've talked to people and we just are convinced or comfortable that that's what's happening and we're letting you know that's the allegations. I said, well, okay, I hear the words. What is being done? What did I do?
He was told what he did.
Huh?
He was told what he did.
And they said, you're sexually harassing people by grabbing the one woman's rear end, I guess is one of the allegations.
Hugging,
and that. And I
inappropriate
guess
comments.
Following it through is, and oh, by the way, you know Judge Eddy and Judge Wallace and the other ones are doing these things too, and you're not telling anybody. Not that Judge Wallace would do that either. But I mean,
Well, I understand.
but I mean,
I understand.
And I said, well, when did I know that? How did I know that? And they say, well, we've talked to people and we know that you know that. And then I say, well, who is it that's saying this about me? Maybe I was in China when this was happening. Maybe I've never heard of this person. Well, we think we're uncomfortable telling you because we promise confidentiality. That would strike me as real troubling that they'd want to remove me from the bench based upon that kind of information that I'm being provided, quote, due process with.
Well, the due process was, again, it was an issue, and Judge Perkins found that it was an issue of whether it was material violations or not.
Let me ask you a question about the due process.
Yes, Judge Berger.
Because and specifically in terms of the testimony of, I believe it's Mrs. Kwiatek, is that how you pronounce the name? Of the expert witness that.
The outside counsel?
Outside
Yes.
counsel that testified. And I have some concerns about her testimony, because looking at some of the things that she was allowed to testify to with regard to whether or not due process was afforded. She testified that BCU did not have a legal obligation to follow the sexual harassment policy, which required BCU to form the committee to investigate. That it was appropriate for them to go directly to the termination provision in the handbook as opposed to the sexual harassment provision. And because the reasons listed for the termination were triggered obviously by the allegations. She testified there's no legal requirement that sexual harassment victim be required to confront their accuser, and that my concern is that this testimony, I mean, an expert's testimony is supposed to assist the jury in determining something in a case, not to answer the question that is ultimately to be decided by the jury. And what my concern is with this witness's testimony is that her testimony actually was the testimony directly to the ultimate question that had to be decided by the jury. And if that's true, why is that not a reason to reverse on that issue alone?
There's several reasons, Judge Berger. First and foremost, when the direct examination of Ms. Parsons Kwiatek was being conducted, our side asked her a couple questions that were opinion testimony, and Judge Perkins sustained those objections. He made it quite clear in the record. When plaintiff's counsel got up to cross-examine Ms. Parsons Kwiatek, they started asking her the same types of questions, opinion questions. In fact, Judge Perkins, if you recall from the record, said, I started making little X's on my notepad, and I ran out of X's the number of times you asked her opinion questions. So when we got back up on redirect examination, we asked her those questions as well. And therefore, Judge Perkins ruled, and he very clearly said it in the record, it's set forth in our brief, that the door had been opened by plaintiff's counsel to that line of questioning. Moreover, the other witnesses are asked similar types of questions. For example, they asked Dr. Lindsay about the faculty handbook and his interpretation of it. And Dr. Lindsay talked about the faculty handbook and gave opinions on the ultimate issues.
Well,
So,
the opening of the door, concept of law. I mean, it's not a black and white, though. I mean, there can be a door opening, but that doesn't mean it's Katie barred the door. I mean, I guess we're talking about doors now, but Katie barred the door here. I mean, it seems like your argument in response to Judge Berger is, well, if they've opened the door, then it's a free-for-all. I could ask, and I understand that you may have not asked it, or trial counsel may have not asked it this way, but that doesn't then mean that on redirect, you can ask the expert, well, now that you're an expert, who do you think should win? Right? I mean,
I agree with that, Judge Lambert,
okay,
but in this...
in essence, I mean, it's really troubling, as a former trial attorney and trial circuit judge for a long time, to sit there and say, in essence, this is the lady counsel hired by Bethune-Cookman as outside counsel to give guidance and information and counsel regarding this procedure. She's now called as a witness to say, and in my opinion, I gave them good advice and they complied with everything that they needed to do under this contract. I mean, in essence, she's saying, maybe not expressly, she's in essence saying, there's no breach here. There's no material breach here, which clearly an expert witness can't do. They can provide expert testimony to assist the fact finder in determining the facts, but they can't tell them how to decide, and that seems to be the real problem here.
Well, she wasn't called for that reason. She was called for the good faith defense, which under procedural due process we're entitled to present. And we did present that. And it wasn't Katie bar the door. We were allowed to redirect her on questions they cross-examined her about. And that's what we did. We did it on those very focused issues.
And the good faith defense was to what? What was the good faith defense a defense to?
The procedural
breach of contract.
Procedural due process. It's a good faith defense as to what we conducted to determine whether he got procedural due process or not. And Judge Perkins made that very clear in the record. He stated that was one of the reasons why that we were allowed to put on a good faith defense, which we did. The exigent circumstances, that this was not just a single complaint, it involved multiple students, it involved multiple professors, it had been occurring for years. It wasn't just one person complaining about an inappropriate comment or an inappropriate touching. It was multiple things. It was trading sex for grades, it was passing around naked pictures of students, it was students being...
But as to a contract claim, I mean, there's not an independent breach of a good faith provisions of a contract. In other words, I can't sue you for a breach of contract, and the defense say, well, what's the breach? It says, well, you're not acting in good faith in the contract, so there's an underlying or implied good faith in the contract, and you're breaching. There has to be some express breach, and you seem to be saying that even though I breached the contract, if I did it in good faith, it's not a recoverable breach, which I conceptually have a hard time. That's like saying if I'm hired somebody to build my house, and I want a certain type of roof or certain something in my house, and I have a contractor friend who goes by my house and says, you know, I heard from somebody that they're really not putting that kind of material in the house that you wanted, and I said, well, okay, I'm not going to pay my contractor because they're not doing what I contracted for them to do, and so I don't pay them, and they sue me. Then I defend, say, well, I have a good faith belief that you weren't complying because my friend who's a contractor talked to somebody else who said you weren't doing these things. That strikes me as not really a defense to a breach of contract action, and I have a hard time how that supersedes and entitles the admissibility of this report, which is grossly prejudicial to Dr. Mootry.
Judge Lambert, let me address your question in a couple parts, if I may, and I may run out of time when I'm answering it. May I have additional time to address His Honor's question? Thank you. First and foremost, there were two parts to the breach of contract action, as we know. One was, did Dr. Mootry sexually harass anyone, or did he witness sexual harassment and not do anything about it? At the time of the motion for summary judgment, partial summary judgment, there was ample evidence in the record that he did. We had the testimony of Raquel Tapia, who he knew about. His lawyers were there. They took her deposition, and she said that he made inappropriate comments. He watched other professors sexually harass me and did nothing about it. We had the deposition testimony of Paul McComb, who said he was there and he questioned these professors, Dr. Mootry and the other three who were terminated, about why they were passing out nude pictures of students on the cell phone, or passing around on the cell phone, and he confronted them with the allegations he was told about, and he was told, and these professors, right in front of Dr. Mootry, according to Mr. McComb, Professor McComb said, yeah, in fact, we threaten the students, we're going to put Facebook postings if they're reported. So there's retaliation there. That goes to the causation issue. To the procedural due process issue, it goes to the materiality issue. In the procedural due process, as we've argued, and as we set forth in our brief, there were a number of things he had that he went through, that he was provided procedural due process. The issue with regard to the materiality and the issue with regard to whether material due process was provided, that's where the good faith defense goes to. It goes to that portion of it, because there's an ambiguity in the contract. There's an ambiguity in the contract in the handbook, and there's an ambiguity within the handbook, which pages apply. It was our position from day one that the handbook doesn't apply, that it's only the contract, because it's set forth right in the preamble to the handbook. This shall not form the basis of a contract. The judge ruled contrary to us. But Judge Perkins also said, because there's an ambiguity between the contract and the handbook, and an ambiguity within the handbook itself, that's a question for the jury. And it's a question for the jury to determine whether due process was provided, and the jury made their ruling. The jury heard all this evidence, and that is why the good faith defense on procedural due process is allowed to be into evidence. And to address your last concern, I would agree with you that portions of the Bo Brewer report are hearsay. Clearly they're hearsay. Judge Perkins found that they were hearsay, but he didn't admit it for the truth of the matter asserted. He admitted it because to determine if procedural due process was given. That's why he admitted that report. It was admitted with the limiting instruction. Finally, at the time it was admitted, there was still a defamation claim against Bethune-Cookman University and Dr. Reed. So it was also admitted for...
How does the report go to show good faith that due process was given?
Judge Berger goes in many ways. First, as you recall, this was an independent investigator who was not on the campus to investigate sexual harassment. He was there to talk to students and faculty about the position and what a vice president of academic affairs should do. This man was then confronted with allegation of sexual harassment.
Right, but why does the content of the report have anything to do? He can testify, he did an investigation, and this is, whatever his findings were in terms of what he testified, without getting into the, for lack of the salacious details that are highly prejudicial when you don't have the accuser coming forward and saying, Dr. Mootry did this to me. So, why is the details and the content of that report, what does that have to do with due process when Mr. Brewer could simply testify that he conducted an investigation?
Well, it goes to two things. First, it goes to the defamation claim, and that was still pending when it was admitted. That's one of the reasons.
When it was admitted, it was, but then the defamation claim went away.
Directed verdict.
And then it was continued to be brought up after the defamation claim went away. So, correct?
Yes.
So, if it only went to the defamation claim, then the fact that it's mentioned after the defamation claim is gone, then there's no reason for it to be mentioned.
Well, it also was important because one of their claims was that Dr. Mootry didn't do anything wrong. He never did anything at all wrong. And there was evidence in that report, which was also deposition evidence from Dr. McComb, for example. He's the visiting professor who was there a year, who said that he saw this.
The way to rebut I never did anything wrong isn't to put in a report that's loaded with hearsay. Mr. Brewer didn't have any firsthand knowledge of whether or not anything was done wrong. The way to rebut that testimony is to call a witness that says he touched me inappropriately.
And they had every right to call Dr. McComb and rebut everything in that report. They had the right to do it, as did we. We chose not to call him. And that's one of the reasons why. I understand the court's question. The due process element goes to what Mr. Brewer did, how he did it, when he did it, and those sort of things. But the details of what occurred were important to show the exigent circumstances.
Very well may have been.
And that's part of the due process.
No, but it's also important to call a witness that can testify firsthand to what happened, not hearsay.
We did call sufficient number of witnesses, and the jury felt that we did. They're criticizing the evidence, the jury made their decision, but the exigent circumstances were also important here, and that's why the details were important. This was not one thing. It was rampant. It was something that was not contemplated by the handbook and could never be contemplated by the handbook. No reasonable university would believe that there were 4 or 5 professors for years sexually harassing students. This is no different than what occurred at Penn State. You can draft all the handbooks you want. Nobody's going to contemplate that an assistant head football coach is sexually molesting children in the football locker room showers.
Counsel, you're out of
can't.
time.
Thank you. We ask that the court affirm, and thank you for your time. Appreciate it.
Quite frankly, the jury was deceived throughout the whole trial. In closing, BCU argued that the only way Dr. Mootry could win is if Ms. Kwiatek was lying, if the 30 anonymous students who supposedly talked to Mr. Brewer was lying, if Mr. Brewer was lying, if everyone that, on BCU's side was lying. And again, there's no direct testimony that Dr. Mootry did anything that violated the sexual harassment policy to begin with. Couple points. How does the report...
Proposal for settlement, for getting past the $100 proposals for settlement, but as to the $140,000 proposal for settlement, in light of the Mathis opinion of this court, written by Judge Berger, actually, and I know Judge Perkins didn't have that's kind of problematic for your situation. I mean, I know it becomes moot if you win here and it gets remanded to a new trial, but if you don't win, then why is that not binding upon...
Did you say $140,000 offer of judgment? I don't...
The 2013 offer, or proposal for settlement, I'm an old guy.
I don't think there was a $140,000 offer. Was there? Oh, okay, I'm sorry. Did the trial court...
The trial judge did not enforce that.
I thought he didn't enforce the $500 offer of judgment and then later did enforce a subsequent offer of judgment for a less, more limited time frame. He denied their initial offer of judgment.
$100 ones, but the $140,000, the one that was made a few months before the trial, the $140,000, I thought he denied the enforceability of that, and your side has acknowledged that Mathis was written subsequent to Judge Perkins' ruling, I think. And
well, Your Honor, I don't remember the details of the $140,000 offer of judgment, so I apologize.
Something else you want to do, but you got 40-some seconds or something.
Okay, how does the report show good faith, you asked Judge Berger? It's a circular argument. It's saying that BCU knew that Dr. Mootry did these things, and therefore, they terminated him in good faith. So, in other words, it circumvents the whole, this isn't coming in to prove the truth of the matter asserted. It is. It's coming in to prove we knew he did these things. I heard him mention McComb a couple times. That was hearsay. There's nothing in the record that shows Paul McComb accused Dr. Mootry of passing around sexually explicit pictures. It was a document that was generated by a faculty member. It was hearsay, and Dr. Reed knew that Mr. McComb said Mootry wasn't involved.
They mentioned testimony of other witnesses. Was there any direct testimony, and I don't remember, it's a large record, is there any direct testimony from any witness that testified that Dr. Mootry committed sexual harassment?
Thank you for asking that question. No, and the reason I say that is because you can't just say, anything is sexual harassment. The policy defines sexual harassment. The court found that the policy was part of the contract, and the contract defines sexual harassment as an unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of sexual nature when 1, 2, or 3, submission of the conduct is made either explicitly or implicitly a term or condition of individual employment or academic success. Submission to or rejection of the conduct by an individual is used as a basis for employment or academic decisions affecting the individual. Or 3, a reasonable person would find that the conduct has a purpose or effect of interfering with the individual's work or academic performance or creating an intimidating, hostile, or offensive work or academic environment. There's no testimony that any of those 3 conditions applied. And
their argument seemed to be that somebody named Dr. Hope, who was a student 40 years ago,
right.
I guess when Mootry first started as a teacher, he asked her out,
right.
And then in the early 90s, she became a colleague of his, and he asked her out, and she said no, and
she said,
that was the quote,
right.
Direct evidence of sexual harassment, if I understood
right.
BETHUNE-COOKMAN's position, something that happened, I guess, 38 years ago. or I guess 34 years contextually, and then,
Right. And the problem with that is, first off, she said that wasn't sexual harassment. She wasn't intimidated. Mootry was never rude to her. She respected him, no problem, okay? She testified that he asked her out, she turned him down, and he was cordial ever since. So you don't have any of those conditions where it's a quid pro quo. You know, this for that. If you don't do this, you're not going to succeed in my class. That's what you need. And the definition goes on to say, for purposes of this policy, sexual harassment also includes sexual assault or rape or other similar actions. It felt the need to go on to specify a few things that wouldn't need the quid pro quo. Rape, that's obvious. But that just shows that you have to have one of these other conditions for it to be a violation of sexual harassment policy. This is a contract action.
Counsel, you're out of time.
Thank you.